Hello, good afternoon. Thank you everybody for coming today. Before we get started, I want to kind of talk a little bit, tell you a little bit about myself, a little bit about Lone Star Legal Aid, and kind of the services, networking that we could provide so that we can continue a working relationship with everyone here and possibly collaborate on not only expunction cases, but any type of cases that affect the poverty population. So again, my name is Ty Nguyen. I'm with Lone Star Legal Aid. I went to law school at South Texas. I graduated in 2009. And before I graduated, I volunteered at Lone Star Legal Aid, and I was working there every day after law school for free. And then when I graduated in 2009, and there's any 2009 graduates, y'all know the economy was tough. So I started volunteering 40 hours a week at Lone Star. And when I passed the bar, I couldn't find a job, and so I went to my managing attorney and said, hey, it's either you hire me on full-time, or y'all got to do some of these educations that I have. So they ended up hiring me full-time, but it's a job, it's my dream job. I always wanted to help poor people, and I have the perfect opportunity to do that. What I currently do now is I'm a managing attorney of the Civil Matters and Criminal Justice Grant. Me and the grant writers at Lone Star, we approached the MacArthur Foundation. We got a MacArthur Foundation grant to help the poverty population in Lone Star in Harris County kind of re-enter into society. It's a smaller grant. MacArthur Foundation gave a multi-million-dollar grant to Harris County to fix the bail reform issues that Commissioner Robbie Ellis and other people are involved with. Obviously, Lone Star is not involved with that, but this is to kind of supplement the bigger grant to move forward. So Lone Star Legal Aid is the largest service provider to low-income families in the district across East Texas. We have 14 offices from Texarkana to Clutie. That's all the way up to East Texas, all the way down to Doria County here in Freeport. And so if you have any clients that are low income, and if you need any assistance, if you're providing pro bono assistance to them, and you just need some expertise or some advice in the areas of poverty law, feel free to reach out to me, feel free to reach out to Lone Star, and hopefully we could provide you with some information in the right direction. So that's kind of a little bit about me, a little bit about Lone Star, so we'll kind of jump right in. This PowerPoint presentation is designed to talk about the basics of expunctions, nondisclosures, and still the juvenile records. Before I got started, I kind of took a survey of most of the people in the room. Most are younger attorneys or attorneys that have practiced but haven't done a lot of expunctions, nondisclosures, and still juvenile records. And I think that's a perfect opportunity to kind of focus in on certain areas of the law that has changed. With particulars to the non-disclosures, there was a major legislative update in September 2015 that kind of creates the architect for to analyze the statute and how it moves. And the big legislative update September 1st, 2017 kind of really opened the door to a lot of non-disclosures that weren't available before, but we'll kind of dive into that inside the conversation. So kind of the first thing, right? Expunctions and non-disclosures are not the same thing. They both serve a similar purpose to clean up criminal records, but their root authority comes from different statutes, right? There are different rules and regulations that apply to them. There's different procedures and different agencies responsible when we start filing these petitions and these applications. So with expunctions, kind of the mechanism in which we analyze it, the starting event is an arrest. So an arrest is not a conviction, right? An arrest is just an arrest, and what do you do with that record? So you could actually expunge the arrest. You could expunge the no bill, you could expunge the not guilty finding, right? But it all has to flow from the event of an arrest, right? And so when you do that, all the government records are destroyed on it, okay? It is not a constitutional right It's not a due process right. It's purely statutory, and it gets its authority from Chapter 55. The way the rule is written, they require, some of the case law is saying that because of the statute, it requires strict compliance. But in the case law, it's saying that we want to have a broad construction where we're reading it. And so, but in practical application, I think a lot of the DAs and the judges kind of understand what's going on, and they're going to allow a broader construction of some of the statute. It's important to note that if a person is being investigated for a crime, no matter how extensive, but there hasn't been an arrest, you can't expunge that. There's nothing to expunge, right? And so it's from that event of the arrest where we kind of get to do the expunction analysis. So there are several categories of expunctions: acquittals and pardons, dismissals and no bills, discretionary expunctions, and identity theft. With the property population, I've had, I think, a lot of it surrounding identity theft. I don't know why. I do know why, because their identity theft usually takes place among family and friends. Like the family and friends are the ones that are doing the identity theft. And because there's so much economic pressure on them, right, they're doing identity theft to their parents to kind of get some money. So I see a lot of that, but we'll get into it. Kind of the first section, so acquittals and pardons. So any person that's been tried for an offense is entitled to an acquittal. Any person that's been tried for an offense and was either acquitted or subsequently pardoned is obviously entitled to an expunction. So when you get an acquittal or a pardon, all that record is still kept with all these agencies, not just with the DA's office or the courts, right? People could pull up your record and see that this person was charged with murder, this person was charged with distribution of narcotics, and this has a broad impact on the employment situation, even though they were found not guilty, right? And so we want to go back and obviously expunge as much as we can. The act of expunsion is not to seal a record, it's to destroy the record. Like the record never existed. So a court cannot order an expunction if there are other convictions or pending prosecution from the same criminal transaction. And I think me and Dylan, we talked about this a little bit, right? So we want to do that, take it back to law school moment where we have to do the criminal episodes analysis. If the DA is going to have an opportunity to pursue other claims, they want to have all their cards on the table so they can negotiate. They're not going to let any of that come through. A person convicted and acquitted on appeal is also eligible for an expunction. So if you're obviously found guilty at the trial court level, your attorneys appeal that, you get an acquittal, then you could expunge that, right? Obviously, a reversal is not enough because there might be a new trial and you can get tried again. But if you are acquitted, then you'll be entitled to. I think I see more of this than actual acquittals and pardons. Like I've never seen a pardon, right? But I see a lot of no bills. I see a lot of dismissals. That may stem from, I think, the sensitive nature of the client population. I think a lot of them may be overcharged just because of what's going on within their living conditions. A lot of times they're unemployed. A lot of times they're just standing around in the park or looking for a job or just socializing. And the cops will arrest them and charge them. So there's not enough evidence in the back, so it ends up getting no bills by the attorney. And so we want to also clean that up, right? And so I see a lot of no bills. But obviously they must be released and the case is not pending. The case must not have been resulted in a final conviction, and the petitioners must not have served community supervision for any of the offenses. So once we meet those three criteria, the analysis fits into where it requires us to kind of fall into one of these three categories. The statute of limitations has that ran, or the waiting period has passed, or the case was dismissed for certain reasons. We'll go into those reasons. A petitioner is eligible for expunction if the prosecution is no longer possible because the statute of limitations is off. That's pretty obvious. You kind of, like if the DA can't prosecute anymore, then we can close. The waiting period is kind of the common analysis in this. So if there's no indictment information that's been filed against the petitioner by the time the waiting period expires, then he's entitled to an expunction. So the waiting period for Class C misdemeanor is 6 months. The waiting period for a Class A or Class B is 1 year, and it's 3 years for felony. Petitioners must prove an indictment if information is filed and the case is subsequently dismissed. So I don't want to just read the PowerPoint to you because I think everybody here could read the PowerPoint. And moving forward, maybe I'll just kind of talk about what's on the PowerPoint and kind of my perspective of it. And so I think the burden, right, in a criminal prosecution, the burden is on the state to prove everything. But once you do an expunction, then the burden is really on the petitioner. We have to prove, right, our clients and the attorney, we have to prove what we're asking for. And if we're going to go down this analysis, we got to prove that the indictment was void, or they completed pre-trial diversion, or there was no probable cause. This discretionary expunction is pretty hard. Not the legwork part of it, but it's hard to ever see or pop up. I was talking to Ira about this earlier. Like a lot of the ADA, they want to push this stuff. Like the ADA's office has never given me a problem about it. If the client qualifies, then they're going to kind of want to get it done. I feel that the ADA's office would be doing it if they had resources. They're just working on limited resources, so they can't. And so inside of that world, we kind of have this discretionary thing where it's up to the judge. And if you have a recommendation from the DA that it's going to happen, it's most likely going to happen. And so in my 8 years of practice, I've never even filed one because the DA either gives me an absolute reason why we couldn't get it, and there was no point in bringing it in front of the judge. But I think if you do have a very compelling case, some of them are discretionary. You can take it under supervision. And so I kind of want to spend some time on this identity theft one because I see it a lot with the poverty population. So what happens, in my experience, is a person is arrested and then lies about their true identity. It could be a very common name, like John Smith. And a lot of times, this John Smith person is, has a 4th grade or 5th grade education, is not very articulate, doesn't have a lot of identification on him. He just tells them that he's John Smith. The police agency kind of runs the record and says, okay, you're this John Smith, right? This is your birthday? And they just say, yeah. And they go in front of the judge, they go through the criminal procedure in the process, and they plead. They say, yeah, I'm guilty, I'll do 6 months for that. They do 6 months. Their actual name is John Smith, but the DA is processing the case for a wrong John Smith, with a wrong social security number, with a wrong date of birth. So those clients kind of come and say, hey, I can't get a job now. Or my most recent example is my client coming to me saying, I can't get on Section 8 housing. I'm entitled to it in every kind of way, in every other way, but I can't get it because they say that I have this criminal record, that I was found guilty of these offenses. And I was like, okay, but you did it, right? And they're like, no, I didn't. Same person, same name, different birthday, different social security. So like, how do we go back and fix that? So for the newer cases, everything's fingerprint now. If there are any criminal defense lawyers in the room, you know, anytime you go through that criminal procedure process, you get in front of the judge, you plead no contest, guilty, not guilty. You gotta, it's not your signature they're looking for anymore, it's your fingerprint now. And so what we do is we go back and we double check the fingerprint, right? And if that fingerprint doesn't match, then the DAs are always very, very accommodating to kind of getting the right person clean up their record. So I kind of hinted on this earlier that the expunctions they're civil in nature. The burden of proof is on us, it's not on the state. For acquittals and actual innocence belief, we could follow that with the trial court. For dismissals and discretionary expunctions, we could follow that with the the district court where the arrest took place or where the offense was alleged. So, like I was saying earlier, the statute kind of requires the strict compliance nature to it, and these are the things that need to be on there. In the back of your packet, or in addition to your packet, and also a jump drive should have been provided, there are template pleadings in the back. And so the function one is the one that I actually followed, and it meets all the statutory requirements. Fill in the blanks, you guys just amend it and kind of do what you need, but all the information is on there, kind of what you need. So all the obvious things need to be on there: name, date of offense, driver's license, social security, to make sure they kind of get the right person, offense charges, and stuff like that. It's important to know, like, who keeps these records. So I've done this twice for a client, because after we filed some non-disclosures and got it granted, some of these third-party agencies still hold on to the record. So obviously the state agency, several state agencies hold on to the record, federal agencies hold on to the record, but there's these third-party data buying companies that report on this stuff too. Kind of the best way to get to all the information, in my experience, is through the fingerprint test. Obviously, everybody in the room probably passed the bar and did the moral character and fitness test, and when we had to do that, we had to do that fingerprint test, right? If you're willing to pay for that and get that out, that'll get us to a lot of the information at the federal level and state level. Yes, sir?
Maybe skipping ahead, but so you're filing this petition, you're asking for that relief, but you want that petition to be expunged as well. So I'm assuming the order that you attach at the end of this will request that the judge expunge either the petition that you filed.
Correct. So they'll, within certain regulatory time frames, so for expunges 30 days, non-disclosure 60 days, and some juvenile records, it's like 61 days. But what happens is they're gonna take it offline, right? So you can't see it. Me and Dylan was talking about this morning, where you file the expunsion, you get the expunsion, and then you yourself can't get to the records anymore because it's all offline. You got to go to the courthouse, you know, you got to go down to the basement, you got to pull it out of the boxes. Because the subsequent litigation is with the third-party information buyers, and they're still disseminating this stuff, right? And we've got to contact them and say, hey, we're going to file a lawsuit on you guys if you guys don't clean this up. And here's a record of what happened and how we cleaned it up. And to get to that, if you don't have it already, then you got to go physically go get it. So I guess
the first step is to get a copy of the file.
Yeah, and then maintain it, you know, at least for 5 years, I think, or just.
You got to do it within that window, within that 30-day.
30-day window.
Yes.
Yeah, it's very, very hard to get it after that. But there's a way, you know. But that's definitely what you want to do.
But I guess, you know, there's always going to be a paper trail.
Absolutely.
Okay, because even that effort to contact these third-party entities, you know, someone who may be assaulted later by someone who was accused of assaulting someone else, you know, may seek discovery from those entities. There's no way you're going to stop that from happening.
You're correct. So it's not an absolute thing, right? Once you file a petition for expunction and it's granted, it doesn't mean that everybody in the world is prohibited from talking about that no record exists. It's just what official statement the petitioner can make after it's done. They can say, I've never been charged. And then how the government reacts to that. So in an expunction, the government can't even talk about those things happening because it never happened. But if it's on somebody's Facebook, it's going to stay on somebody's Facebook. If it's on someone's Twitter, like it's not going anywhere, right? And I think the law, you know, the law is behind on that. And I don't know how they fix that. I don't know if there's a way to completely take it off the world's record, but the official record and the government record, how we proceed, I think is what the
Well, it would seem to me that there's a basis for asking these third-party folks that collect this kind of information from publishing it. Then is the statute, I guess, broad enough to go out to Facebook or go out.
That's right.
Yeah,
That's right. So it's not right now. So the statute specifically says if you're a third-party data provider and you do it for a fee, then you're subject. And you gotta take remedial measures to get the record clean. But if it's just public library information, Facebook information, Twitter information, it's just out there, the statute doesn't even contemplate on how to address it.
One more question.
Absolutely.
I believe, as you were going through some of the earlier slides, that a person who has undergone supervision cannot take advantage of this expunction.
Correct.
Okay.
Correct. Because it automatically pushes them to non-disclosure territory. So the non-disclosure is the sealing of a record, which could be open and it still exists. The expunction of a record is it's gone. Expunction is destroyed. No one knows it exists. What official government people don't know it exists. So if they went through community supervision, probation, deferred adjudication, then they squarely jump into the non-disclosure territory. There's some legislative updates that actually allow for now expunctions when there have been convictions. So you could have been convicted, serve some jail time, and still get that sealed. And I think a lot of my work and my experience is really the non-disclosure. Very few expunctions actually cross my desk. But we'll get into that. I hope I answered your question.
No, you did.
Thank you. And so these are kind of like the list of agencies that have all this stuff, and the petition requires that we include all of them so that the orders could be issued against these agencies. And these agencies are actually respondents. They, for whatever reason, could file a response and file an objection to the expunction itself, and they're going to get a right to a hearing if they want to. And so it's just a list of, if the defendant or the petitioner committed a crime in Harris County, you want to make sure you get all the Harris County agencies involved. In my template form in the back, all of that's there for the Harris County. Obviously, if you have a client that did it in Brazoria County, Galveston County, you kind of want to research which agency is holding all those criminal records and make sure you get the petition right there. So this is kind of what I just said, that these agencies, they have a right to the hearing, so they have to get at least 30 days notice. But honestly, no agency has ever pushed back, in my experience. It has always been the district attorney's office saying, hey, this one's not a good one. Because it was my fault, I didn't do a complete criminal history search or pursuant to my client's advice to me, that nothing else was done, but it was kind of dig a little bit deeper than the client does. So there is a way for them to oppose. If they don't oppose, you could rely on your pleading, your petition with all your attachments and exhibits. You can rely on that. If there is a general denial by any of the agencies, then you got to rely on your proof at that evidentiary hearing of record. Right? So any one of the respondents could file a notice of appeal. It's kind of civil in nature. They could file an appeal. If the appeal overturns it, then it applies to all the respondents.
Excuse me, Ty.
Yeah.
Are you going to speak on the type of proof that we will put in with our petition?
We can.
And when you do that?
So the petition should include all the evidence you need, obviously, that you meet the statutory requirements. But some of the statutory requirements for certain crimes or offenses require a best interest of justice test and analysis to be done. It is my understanding as of last week when I did research on this very issue, there is no definitive case law that says what is in the best interest of justice when it comes to expunctions of non-disclosure. Right? So we just kind of put out what we have to put out to say, my client is entitled to an expunction or a non-disclosure. He hasn't been able to get a job. Here's the 16 applications that he did. We did a fingerprint background test for him. It's shown up on his criminal record, but he got it no-billed or he got it dismissed. Because he lost 3 months of salary, his average income is $3,000, and so he lost $9,000, $12,000. and he needs that money to provide for his family, because, you know, just kind of prove up the best interest of justice test through the eyes of the client, the eyes of the petitioner. You know, usually they get testified on it, you put it on the record. I've submitted job applications as exhibits and stuff like that, but usually it's not a problem. Yeah.
Earlier you mentioned that there were a few times, I guess, where there was some other information out there that the client didn't tell you. Can you give an example of what we should be looking for additionally?
Let me try to do this without giving out any confidential information. So early on when I was practicing at Lone Star, we had a lot of clients from Louisiana coming to Houston. And they're like, yeah, you know, I've been in Houston for 4 years. I was charged with X, Y, and Z when I was here in Houston. I don't have any offenses in Louisiana. I'm trying to dig around Louisiana to see what happens. I can't figure it out. You know, I just don't know. And so I still filed it. Like, hey, it's only this one offense. Like, not a problem. And the DAs, they contacted me back. They're like, yeah, no, we're going to oppose this one. Your guy doesn't even qualify. A lot of times, the clients, they don't know what county they live in. Like, I could ask them, like, where are you coming in from? You know, I live in Southwest Houston. They could be coming from Fort Bend, right? And they could have criminal records in Fort Bend County. And they could have criminal records in Harris County. Like, they work in Harris County, but they live in Fort Bend. So you got to check both of those counties. The most comprehensive way to do it would be through the fingerprint, right? You got to kind of pay for it, and it takes a few weeks to kind of get it back. That's the unequivocal one. Usually, in my experience, it's not the client's intent. It's not the client's intent to mislead. I think they're just not very sophisticated, especially with my client population. Maybe like the cases y'all get, they're more articulate. They have a higher education level, so they kind of articulate their problem better. But my client population, a lot of it, you know, they're coming in with 5th grade, 6th grade education level. I don't think it's their intent to mislead. They just, you know, they're like, yeah, I live in Houston, you know, but they really live in Sugarland, Fort Bend, and you just got to kind of dig and figure it out. So does that answer your question?
I think so.
So kind of talking about non-disclosures, and I think I hinted this when I was talking to Dwayne. So in the world of expunctions, it's all gone. In the world of non-disclosures, it still sits there. We're just seeking the court to kind of seal it. So if your client is given a deferred adjudication or probation, or now even jail time in very non-violent minor offenses, they could file for an order of non-disclosure. And the analysis is different. The analysis isn't arrest-based. It's not an arrest event that allows you to do the analysis and say, okay, we can do an expunction now and seal the arrest record, the no bill, the acquittal record. The expunction is offense-based, right? Because the non-disclosure, there may not be a acquittal phase to it. It was just your client plead, you know, guilty or no contest, put him deferred, and there was no trial, so there didn't even a trial order to kind of non-disclose. So it's very offense-based. So when we dig into the statute and you have to do the analytics of it, you see how it's infinite. So before September 1st, there were less areas, and now after September 1st, there are more areas. I think this last legislative update was a big one for petitioners and defendants, and I think that the legislature is really opening up non-disclosures for it to be used. So kind of all the areas that I'm going to go through are the petitioners are entitled to a non-disclosure for certain misdemeanors, which is automatically done. You don't have to file a petition. But if you find an error and it's not non-disclosed, you have to write a letter to the district attorney's office letting them know that it exists, and they'll let you know if you qualify or not. And a sample letter is attached to the work product. The next one is a standard deferred non-disclosure. This is the 2015 to 2017 analysis, where there's a grouping of cases that require the defendant to have been placed on deferred adjudication, go through a specific waiting period after the deferred adjudication is granted, And then you can file the non-disclosure, which gives them the right to say, I've never been convicted of that, I've never been charged with that. There's a completion for a veterans treatment program. I personally never did that. If you do, please contact Lone Star. We have a veterans unit that specializes on military issues, and there are attorneys in there that have gone through the non-disclosures for the veterans that complete the treatment program. The human trafficking one, if you have a client or a defendant that has been charged with prostitution, but it's due to a human trafficking event, then you can get that non-disclosed. This one's pretty common, the straight probation for certain misdemeanors. I think that it'll grow. I think a lot of people probably qualify for that. I think the next big one, and I'll spend some time on this one because it's brand new, as of September 1st, 2017, defendants could get DWIs non-disclosed. Right? And that's a big one. And then misdemeanor jail time. So for some non-violent stuff, even if they spent jail time, you can get it non-disclosed to say they never talked about it. Usually it's a one offense thing. So you can do a real quick analysis. If they've been charged with a bunch of DWIs, you can't do it. If they've been charged with one, you can. If they've been charged with one non-violent, then you can file a non-disclosure. So it's usually the one. These are restricted offenses that you cannot file a non-disclosure for. So the defendant was charged, took deferred adjudication, now they're here. If they've been charged with any of these events, there's, non-disclosure, right? Trust me, I've asked. Believe me, I've asked the DA to non-disclose a murder charge.
Really?
Yeah, I have.
On what ground?
I have.
To the extent you can.
Because it's bad. Like, no bill was dropped. Like, actually, it was an expunction of the record, right?
Yeah, okay.
Saying like, hey, no bill was dropped. Like, and the DA called me back, like, no. Like the ADA, right? Called me back and said, no, we're still looking at the case. Right, my client had a bigger problem at that time. Yeah. Right? Don't worry about yours. But we've asked, and it's been denied. That's interesting. But any of the major stuff, like family violence, any felony enhancement, anytime you hear like any type of felony enhancement, an assault with a family member, automatically enhance their felony. A DWI, you got a child in the back, automatic enhancement. If it has an enhancement to it, you probably can't do the non-disclosure. So these are the automatic non-disclosures. Nothing is filed with the court. If you find out that your client has one of these offenses and it's not non-disclosed, you need to write a letter to the ADA's office, the district attorney's office, to kind of let them know about it. It's pretty much common sense stuff, but if you're looking for the root authority, it's there on the PowerPoint. Just think non-violent crime, a lot of drug-related offenses and stuff like that.
Is that includes marijuana possession? Yeah, that's good.
So, so this is kind of a nuanced thing, or maybe not a nuanced thing, but they must have completed community supervision, and it must be 180 days from the time they were placed on supervision. So it could be a situation where they're placed on community supervision for 2 years. You have to wait until the 2 years are done. If they're placed on community supervision for 3 months, you wait for 180 days to be done. Right? So it has to meet one of those criteria. But I think the DAs, they're really trying to process it, and it's really as automatic as it can be. This is the one that kind of requires our analysis, and I think a lot of clients come in with this problem, which is the standard deferral, which was affected by the 2015 legislative update, and then again with 2017. So it applies to any person who received deferred adjudication for an offense other than the one that the long list of very heavy, violent, family-related offenses kind of get into this analysis here. So they must have successfully been discharged and dismissed from deferred adjudication. So they cannot have violated their deferred adjudication. Right? It cannot be a situation where they were put on deferred. They have to go to the probation officer's test off of Old Spanish Trail and, be dirty 3 times. Like, it's not going to happen. So they have to successfully complete it, and once they do, they have to complete the waiting period. Felony waiting period for 5 years, and misdemeanor waiting periods are 2 years. This is kind of what I was talking to you about, right? Like there's no actual limitation, there's no statute of limitations to this work. So you don't have to worry about holding a case too long. But if your client commits an offense, then they're not going to be eligible for it anymore. So that's a different limitation, a different statute, I guess.
Question for you.
Yep.
So, it's for adjudication, and there's some issues with their compliance. But is there a scenario where there may be issues with their compliance? Somehow they're rehabilitated, that whatever issue it was for adjudication successfully completed.
Absolutely.
Scenario,
Absolutely.
they're eligible.
Absolutely. They're still eligible if they complete it.
Yeah.
So usually with the probation officer, it's kind of one time. They won't recommend anything to the judge and kind of give you a free pass. And it kind of depends on what for the ADA to break the community supervision, right? If a part of the community supervision is, for example, the client gets a DWI charge. A part of the community supervision provision is they have to go to AA for 2 years. They have to go 2 times a week. And for whatever reason, they don't get their paper signed at an AA meeting. They don't go to all the minimum classes. Right? The probation officer is going to elevate that issue since it's a non-compliance issue. They're going to elevate it to ADA's office. The ADA is going to look at it and say, this person's still trying, though. They're following on the other ones, so I'm going to keep them in there. I'm just going to renegotiate. So it used to be a year, now it's a year and a half for that thing. So that will still qualify. But let's say you're in there for a drug offense. You pissed dirty 3 times. They're going to say no more community supervision for you. You got to serve the 6 months for it, or whatever, or 1 year for it. And so obviously, or maybe not obviously, right? If the community vision is still in play, if you still complete it, then your client is allowed to complete the time. So to answer your question, I'm not going to spend that much time on this one because I don't know that much about the Veterans Treatment Program, but know that it's there. I've done this one time. It's actually pretty rare to see, especially with the current present administration and how they're moving forward with immigration issues. So I represented a client that was detained over here by Kushner, Colorado. She was a victim of human trafficking, and her husband, made her do all these jobs. And she was detained. She got caught, and they referred her to immigration. When I was looking at this statute, it's really hard because they require the conviction to be set aside. So you got to wait for that process to get cleaned up on the other end. Obviously, if you had a client come to you and say, hey, I got this judicial clemency, and people are saying that's not a problem, you clean it up. But I think if you get caught right in the middle of it, the waiting period for it is going to be a long time. As practical advice, I would say if you have a client facing these issues, you say, come back until it kind of all gets settled down because they have bigger issues. They have immigration status issues, they have criminal charge issues. We got to wait for all those things to kind of resolve itself, and then it kind of goes into cleaning up the criminal record phase of it. This is a straight probation for misdemeanors. So the person must have received straight probation for a misdemeanor except for a DWI or a gang-related type offense. The person must have never been convicted or placed under further adjudication for any offense other than the traffic ticket stuff. So you must complete the community supervision, and you have to meet your waiting period. And for the analysis that requires the best interest test, I put it on here. So this is an event where you would have to make sure you introduce evidence to your petition or at the hearing that it meets the best interest of justice. Again, this is a new statute. I think a lot of people are just trying to work it out, right? It applies to anyone who successfully completed the DWI probation, right? Probation is not a pretrial diversion. A pretrial diversion is a different animal. I think you're entitled to an expunction in a pretrial diversion. A lot of times, the ADA's office, they're putting in provisions that the DWI defendant go through pretrial diversion, but give up the right to do expunction. And so just kind of be cognizant of what's going on there. So it applies to anyone that's completed a DWI probation. It cannot be a misdemeanor A. So if you get pulled over for drinking, it'll be elevated to a misdemeanor A if your blood alcohol level is too high. It could be elevated to a felony if you got a child in the back. Or if it's your third DWI, it automatically gets escalated to be a felony. So obviously, if you're coming in, you know, you're not going to get non-disclosed. If you completed, you do a 2-year waiting period, and obviously because of legislative update, no one had been 2 years yet. So you know, it's not there, but it'll get there. And if we do have clients that are affected, we want to advise them now so they understand what they're entitled to 2 years from now. So you can't have any previous convictions, can't be placed on deferred adjudication, and obviously no conviction for the blood alcohol level over 12 months. After notice and an opportunity for a hearing, determination is made on the order of non-disclosure in the best interest of justice. So you got to put in those evidentiary proof, kind of prove it up. And there's a no accident rule. I've heard a lawyer when I did an outreach with Abby Group on Saturday. He said that you cannot involve anyone else in your accident. You can't hit another person. You can't have a person in your car. And that was a good way to kind of explain that. If you get into a DWI car wreck and it's unimpole, you're all right. If you get into a car accident and it's unimpole and you're a passenger, you're not going to get it. Right? Obviously, if you hit somebody, you're not going to get it.
Yes, good. So there are any temporal limitations here, meaning, you know, you file your petition, but during the time the petition is pending, you know, you get convicted, or do you have to make those same attestations at the time of the hearing to the extent that there is one, or, you know, are you required to make another disclosure in the event that some of these things actually happen?
That has never happened to me. I would make the disclosure and see what happens. I think that if it does, or they probably don't call it. Just don't. But yeah, that's it.
I have a question.
Yes, ma'am.
I know that you said since you just passed the new legislative update in 17 that someone has to wait 2 years. So does that mean that if someone prior to 2017 September 1st successfully completed probation, then they'll be eligible, but they have to wait 2 years? Or
No, I apologize. There is actually a retroactive provision to it, so it actually is retroactive. I'm glad you asked that question because my statement is incorrect. It is retroactive, so if someone was convicted with an offense, put on probation, completed their probationary term in 2015, right now they would be eligible to 2 years. I apologize. Yes, Abby? Okay. Just confirming that I was wrong? Okay. It won't be the first time. I think the interlock device is yes, ma'am.
You spoke about the prostitution, the effect it have on immigration, but I wanted to ask the expunction. When you do an immigration form, you still have to disclose the expunction.
I'm not sure. I'm not sure.
I've had a client and they said that we didn't disclose. That was one of the reasons for turning him down. But he had an expunction, and his understanding was that it's as if it didn't happen. So
tell me the issue again. You were in immigration court. They're doing an analysis of this person is. No,
he filed for his green card.
Okay.
But he had a incident before, and he had an expunction done.
Okay.
So on the documents that we're submitting to immigration, we said he has never had any he has no criminal history.
Okay. And so immigration found the record.
Yes. They turned him down because they said he failed to disclose.
I would relitigate that issue. I would relitigate it. I'd get a court order. I'd look into
I mean, they sent us back to get to the court to get all, you know, everything back to them, but the fact that he didn't disclose it initially posed a problem.
Yeah.
So,
I don't know, that's a tough one, right? Because I'm advising my clients, like, they're saying after this gets done, do I have to tell them? I tell them, no, you don't. Especially on an expunction because it doesn't exist anymore. So that's a tough
but the INS have everything, so
it's
not like just the other.
I don't know the answer to that. That's tough. Yeah.
I know the FBI have an expunction division, so if you have an immigration client, you may want to notice the FBI in your application, in your petition. I don't know if that'll clear it up for your immigration client for the future, but I think it's going worth a shot.
Could you repeat that? Would you advise like nursing students or law students that they had something expunged if they don't have to disclose it on their application?
That's a tough one. So the expunction, I'm advising my clients that they don't have to disclose it because it does not exist. Like it's nobody's business that I was charged with murder, but I got acquitted. I was found not guilty. Right? I was found not guilty. It didn't happen. I would advocate for that. You know, no one's going to change my mind on that. I do not think we have to disclose that. I think in a non-disclosure setting, you got to tell them, right? Because it's there. It still exists. The non-disclosure statute actually has organizations
Who
that
is
are
them? I'm sorry, when you say you have to disclose to them, I didn't hear the question. Sorry.
Ask the question again.
I was talking about like nursing boards or medical boards or the bar.
So, for example, like the doctor's certification, the bar, they're exempt from the non-disclosures. But, for example, the Texas Real Estate Licensing Board, they're not exempt, so they can't see the non-disclosure stuff, right? But that's my comment to you, which is, if I have an expunction order that says that my record is destroyed on that offense because I was acquitted, then I'm not disclosing that to anybody. I don't have to because it didn't happen. And I think we're entitled to that. I litigate with that.
But you're talking about to an agency, but to that point, I mean, you know, we're hearing all these things about how Trump might get interviewed by Mueller.
Yeah.
I mean, if you're talking to an agent of the federal government, or you're talking to an agent of the states, and they ask you a question, and you don't answer that question truthfully, you know, how are you going to fall back on, well, that particular offense or conviction was expunged?
Correct. So in the non-disclosure statute, it has a provision that says when you're going through a criminal proceeding or you're involved in a criminal event, you have to say that you were charged, that you got a non-disclosure, you got expunged. But when it comes to agencies like getting your licensing, like you don't have to. That's not an event where the statute says that you have to disclose that. The statute's specific. It says that you have a right to deny that it ever happened, except for these situations. Like you're in a criminal proceeding and they're asking you about it. You have to say, yes, I was charged. Yes, my attorney filed for an expunction or non-disclosure and it was granted. That's all you have to say. You don't have to. You have the right to deny, like not even answer any questions about it after that.
So that probably goes to the INS.
But he was talking about a non-disclosure. But you're saying for an expunction, you would say no, flat out it didn't happen.
I would say no, flat out didn't happen if it's any licensing boards. On the immigration issue, I don't know. That's a hard one because it's a judicial thing. It's a government thing. Again, I don't know because I don't practice in immigration. And it leaves up to the better discretion of the attorneys. I don't think the statute speaks on that. It doesn't say in an immigration hearing you have to disclose this. There's no provision, to my knowledge, that statute exists. But there is a statute that says if you're in a criminal proceeding and someone asks you about it, you have to say, I filed, it was granted. But you have the right to you have the right to decline to talk about anything that took place inside of it, right? You don't have to say, I made these statements or these events took place. They can't ask you about it. You say that it is.
I'm sorry, and one more question. If you apply for a government job with a government agency and you have a non-disclosure, I think, is it that they can see the records, government agencies?
So non-disclosures, government agencies, they can see it.
Right. So if you apply to a private employer,
correct,
they can't see it.
Correct.
Okay, because I know there's an issue about when private employers enlist the help of private investigators. Private investigators troll the websites of the courts, and your information comes up.
Correct.
And they're not supposed to be able to rely on that, although they do, and that's a big issue. But I don't know what to do about that.
I don't know what we can do about that now under the current regulatory regime. So I think I don't know if I was talking to you about this prior or not, but one of the things that I see a lot is eviction cases, right? Like my clients get sued for eviction because there's a non-payment rent or lease violation situation. They go to court. We win the case. It says, you know, dismissed in favor or no judgment, right? Take nothing judgment. But these private entities, they're trolling the records just to see if even a lawsuit was filed. And because a lawsuit was filed, they're going to deny it. And I don't know, the statute doesn't contemplate a situation where we have a judicial remedy for these third parties kind of trolling. This is kind of the state of affairs for it. I do want to know the interlock device analysis for the DWI conviction. If there's a interlock device on it, and if the interlock device is for less than 6 months or no interlock device, then the waiting period for the non-disclosure is 5 years. If there is an interlock device on it, then but I think most courts and most AGAs are requiring interlock devices on all DWI cases. So, like I said earlier, it can be a Class A or higher. Can't have a blood alcohol content of 0.5. You've got to complete your sentencing. This is the conviction one, actually. Like if you do any jail time, you're also entitled to a non-disclosure. I haven't seen it yet, but I think what I'm going to see is the client completing every other aspect and then not being able to fulfill the fines, court costs, and restitution costs. And how do we navigate that? I haven't had a chance to personally navigate it, but what I think I'm going to do is file an affidavit of inability to pay costs on it, and then let the court figure out how they want to address that issue. I guess this is a good time to talk about it. So in the legal aid community, we really stand on that affidavit of inability to pay costs, whether it's filed by us or whether it's filed by a defendant or respondent or a petitioner case. We think that everyone should be able to access the justice system, whether they could afford it or not. There's a provision in the law that says if you can't afford it, all court costs is going to be waived. In Tarrant County, there was a situation in the family courts where the legal aid up there was filing or helping assist people file for pro se divorces. And inside of those pro se divorces, they filed an IFP, an affidavit of inability to pay court costs. So the filing fee is waived, everything is waived associated with it. And all these clients went through that process, got a divorce granted, and all just sat there. And a new district clerk was elected, and they thought that they could go and collect from all these petitions, all these people that filed, because the court order says each party will bear their own court costs. So through that, the district clerk literally sent collection letters to indigent people that filed IFPs. And so Legal Aid got involved. We had all of our top appellate attorneys work together. We took it up. They lost. Took it up again and went all the way to the Texas Supreme Court. It's the law case. It stands for the proposition that unequivocally all court costs has to be waived, period, when someone files an IFP, if the IFP is not contested. So for legal aids and organizations, nonprofit organizations that get funding from the Equal Access to Justice, there is a certification document. If we certify that we are providing free legal services and a client files an IFP, it cannot be contested. It cannot be contested by the judge. Like, he has to waive all court costs. For people in the private bar, if you are filing for these petitioners and they're indigent, file it with an IFP, and then file it with another certification saying that you're doing this for free. All right. If you do that, I think that all court costs should be waived with it. Not in relation to the slide, but just in general, like a lot of ALR hearings, these administrative licensing revocation hearings, they're done on surcharges, right? Someone can get a DWI, they're about to get the driver's license pulled. There's a bunch of surcharges associated with that event. The IFP, the affidavit of inability to pay, is supposed to knock out all of the surcharges. And so we're going to rely on the strength of the affidavit of inability to pay. If anybody in a private bar has an issue with that, please contact me directly. Please contact Lone Star Legal Aid. Because that affidavit is not just us, right? It's every single client, whether they have an attorney or not, going to court, throwing themselves at the mercy of the court, saying, I'm poor, I can't afford this, and then to have justice be denied is a travesty, right? So we want to look at it, and we will litigate it.
If you're in a private bar, how do you get a certification?
I wouldn't call it a certification. I don't think it's in one of my forms,
okay.
But I want you to email me. I can give you my certification, and I think you could title it something else. You could title it a Certificate of Pro Bono Services.
Okay.
You say, through my law firm, I'm helping this indigent client on pro bono services. I'm not charging them. They file an IFP. All court costs need to get waived. If you do that, it's uncontestable. If you don't do it with a certificate, they can contest it, and they'll have an evidentiary hearing over the client's indigency status. And believe it or not, some people actually want to have that hearing. So
Can you just send that out?
I can.
If you send it to myself or Sherilyn, we can get it.
Attached with my documents is actually an affidavit of inability to pay. Is that on there? Is that one of the documents? I'll send the affidavit of inability to pay and the certification that I use. And so the private bar could do pro bono certification. Let's just call it a pro bono certification. And y'all let us know if you guys are getting that contested or not. Because there are people that just want to have evidentiary hearings over how poor a client really is. I feel like if a client is throwing themselves at the mercy of the court saying that I am poor, for me that's kind of. So kind of same waiting period with the interlocutor fighting. Please note that. Misdemeanor jail fines, they're allowing non-disclosures, even for people going to jail. And it works just like the probationary non-disclosures. So you guys can kind of read that basically your waiting period. So applying for the actual non-disclosure itself, the non-disclosure petition should include all these things. All these things are included in the template forms that are included in the work product.
Ty, I have a question for you.
Yep.
Before the client comes to us, will there be any sort of screening? Maybe I jumped the gun a little bit. Do they go through you and you will have kind of screened them, or they just will come directly to us and then we will go through this entire screening process?
I kind of want to let Ms. Jenkins speak on that issue.
With Earl Call, we're going to pre-screen. They will be pre-screened so that hopefully that when we give the cases to you, the clients to you, then you won't have to worry about that. We've gotten their criminal records, their court records, etc. So we're going to pre-screen.
And the other question I had, when you mentioned earlier about getting fingerprinting done, just even if it's not through Earl Carr, is that to go to one of those places like Identigo or something where they do it?
Do you know if vegan law is still referring clients, taking clients?
I don't know.
You said
if they're
vegan law?
Still
Yeah.
referring.
I did a workshop with them where we did an intake. You know, they put out the flyers in the community, said, hey, why don't you come and see about your current status? So they are, yeah.
Which event was that at? The location?
It was off of Calvin King.
Okay.
At a community, was the community center? I can
Yeah. I think I know which one you were talking about. So Beacon Law is another nonprofit organization, and they also provide, they're trying to concentrate. They recently got a grant from TJEF, the Equal Access to Justice Foundation, to work on some of these issues. They're supposed to be part of the CleanSlate cooperative.
And My Brother's Keeper.
And My Brother's Keeper and all that.
Juvenile Law Center.
But it's my understanding that the three groups that are processing actual cases is Beacon Law, Lone Star Legal Aid, and the private bar, that you guys volunteering your time. My Brother's Keeper is just a nonprofit, so they're kind of processing and throwing that event and providing other advice to us. They're not processing the case. So if you have any questions, feel free to email me, reach out to me personally. And Beacon Law is also an asset. So in regards to applying for these non-disclosures, it requires all these things that are in the template form. Those template forms have been used by me. They have been approved. They've gotten non-disclosure orders for people. So to the best of my knowledge, they're still good. I will call them and see what the other side says about it. It's pretty streamlined. It's not a complicated process. It's all forms. You file it. The court is the one that provides the notice. Usually other people aren't even fighting. You just kind of have to do it and get it done until the records are fine. Again, like Expunctions, the non-disclosure, the petitioner kind of carries the burden. They have to prove that they're eligible. A hearing is not required if there's no one contesting it, no one files an answer, no one files an objection, there's no actual hearing that is required. When there's no hearing, you rely on your pleading. The eligibility is determined on your pleading. The best interest of justice test is determined on your pleading. If anyone objects, then you cannot rely on those pleadings. You have to go to the evidentiary hearing and present that evidence, whether it be through a business records affidavit or your client's testimony some way, somehow. You got to get through the evidentiary hurdles of hearsay and all that to kind of get it into the record to make sure that the record is preserved or any errors is preserved on appeal. I don't think it's going to be that big of an issue.
Can you rely on evidence that you did not present with your pleading?
You can.
Okay.
You can.
And when you say that notice must be given to the state, is that like service or the court?
Yeah.
Okay.
So, the agencies will get notices from the court. The agencies that are involved in your pleading. So when you file a non-disclosure, you want to make sure you get all the parties involved that are holding on to the record. So if you have a defendant that was arrested in San Antonio, you're not going to notice the Houston Police Department, right? If you got a client that was arrested by the Houston Police Department, you're going to put them on your order of non-disclosure because they're going to get an order that says, this is sealed now. Right? Stop talking about it. Stop giving it out to other people. They have a right to hold it, so they can't give it out to non-governmental organizations. They'll get a notice from the court. Right? The state is the ADA's office serving them, saying, hey, this is what's happening. I always do a courtesy thing where it's like, hey, I'm going to send you the letter. I'm sending the district attorney's office a letter with a copy of the petition before I file it with the proposed order, saying, hey, this is what we plan to do. Do you guys object? And it's kind of like Ira's experience. The DA's office, they want to do these things. They're not fighting back at all. It's just they don't have the physical manpower to get it done because they got limited resources and they're trying to prosecute and get criminals off the street. So I understand it. So it kind of just relies. They're falling back on the private bar. They're falling back on the legal aid organizations to kind of help the clients get it done and get moving.
Okay, so I'll just say that the 2 times that I did it, we walked the application over, right, to the intake window. And we gave the clerk and got the stamps. But then we walked the petition down to the DA's office and said, listen, this is what we just, as a courtesy, right? They come, they look at you through the peephole. I mean, I don't know criminal law, so it's very odd. But they look at you through the peephole to see, that you're not out to get any one of them. And then a hand comes out and says, what do you want? You say, look, it's a courtesy copy. You say, thank you, and they slam the door. But, I haven't been opposed yet. And one thing, as far as the agencies go, in my petitions, I put agencies that I didn't even know if he had any contact with. I did 2 juvenile, right? Yeah. I just made the list extensive as I could.
Yeah.
You know, and it's just the legwork comes in that you have to, you know, send the proposed order, right, in mailings to each agency that you list. So that's a little bit of the legwork, right? You have to send them letters, but other than that, I mean, I guess the more you put, the better, right?
Yeah.
So what happens if you don't put one, but later on there is this non-disclosure? I mean, it doesn't have any effect on the ones that you don't list.
Correct.
So you don't know.
Correct.
Yeah.
You don't know. I think you just got to kind of meet the client's needs right then. Right? Oftentimes I ask my clients, like, why do you need a non-disclosure? Like, tell me what the real problem is. The real problem isn't them thinking that they need this non-disclosure that they don't even know exists. There is a root problem. It's, I can't pay rent next month and I need to get a job. Then it's who did you apply with? What kind of job are you trying to get? Is it a government agency? Is it a quasi-government agency? Or are you trying to get your cosmetology license? Like, what is the real problem? And then just kind of make sure the real problem people get the notices, and then, you know, you're fine, right? Because you can't think of every contemplatable person or agency that needs to be on this. Yes, ma'am.
So if your client knows that one of these private third-party agencies has their criminal records listed on there, it's okay to add that in the petition and the order?
If the agency makes money off of selling that information, the answer is yes. Right, but like what I'm seeing is, you know, it's very hard to clean the internet right now. Right? I mean, that's what our government is dealing with, like, you know, fake news, right? Very hard to clean it up. Like even when they weren't charged, like, you know.
So then is it advisable, like there's certain third-party agencies that I use in the family law area all the time, like TLO and Accurate, and it has a whole lot of criminal records in there. Is it advisable then to just add them into every petition?
I think that's what I was telling Ira, right? Which is you identify what your client's real problem is and make sure the parties that are involved with the real problem are added onto the list. There's some unique issues with juvenile sealing records right now. A lot of it has moved into automatic sealing. Like they're supposed to automatically seal these things. I don't think the attorneys or even the government has figured out how to make sure all these things are automatically sealed and to what extent that they're sealed, because there's a lot of parties involved. Yes, sir.
Yeah, I will say the subject. I mean, you know, in Europe there's this right to be forgotten movement, but this concept of, hey, you know, I don't want anyone to know what happened. It's at odds really with the First Amendment, so it's a big issue. And I think what I'm hearing from you is that I guess the agencies that are listed on there are agencies that for sure we can advise the client, you know, hey, these agencies cannot report, they must, you know, get rid of this information, but everything else, you know, there's no guarantee to that, and there's no statutory right.
Correct. Correct. That is absolutely correct. Absolutely. Does that answer your question? So this is just more applying for the non-disclosure. There's a link on here. That's probably a really good link for you guys to know about. That's actually all the forms for the 7 non-disclosures, even the new ones that are created. The Court of Administration issues their updated forms for each and every single one of them with proposed orders. So if you go with the form, the court issued form, it's going to get back. So juvenile records. I want to disclose that Sarah Guthrie of Borough Park Institute asked me to present on this issue, to add it to my slides. I want to disclose to y'all that I do not have great experience in the area. I've been working on it for like 8 months. I have some clients that are interested in some issues, but I don't have any subject matter expertise, so if I'm wrong, some of the people in the audience with family law experience, please speak up. So it's my understanding that there were big legislative updates in 2017 for it. A lot of the criminal records now are going to be moved to automatic sealing. Like they themselves, the court themselves, have to move to seal these records. Obviously, sealing of a record not the destruction of that record, but just sealing it. And then there are groupings of cases where we, as attorneys, have to file an application to get it sealed, right? And I'll kind of go through that in its most rudimentary form. So as attorneys, we have a right to get to the criminal records. The juveniles themselves have a right to those records. And certain entities now that used to have access to it are now prohibited from sealing records that have been sealed. They used to have access and now they don't. And you can find that who has access to that citation. There are two types of broader offenses classification. One is the conduct indicating a need for supervision. These are the lesser, non-violent type crimes that a juvenile faces, like curfew, run away, puffing is sniffing paint and inhalants and stuff like that. Violation of behavioral issues in the district court. I think there was also a legislative change that law enforcement that are working with the school district cannot issue citations anymore. It has to go through the district attorney's office now, because I think there were several problems with them kind of using their discretion in a not so fair way to issue citations against vulnerable populations in the public school system. And so there are some reform movements on who can actually issue these offenses and these citations in like a high school setting or middle school setting. The delinquent conduct is the more serious stuff. The Class B misdemeanors are higher. Some examples are contempt of court, intoxication offenses, and DWI by minors. So this is an eligibility where it doesn't require an application. Right? It's just going to be done automatically by the court, and the court has to send orders within the time of eligibility to the responsible organizations. There are, Texas Department of Public Safety and a lot of other agencies under them automatically propagate some of these records to make sure all Texas has them. But once the eligibility is triggered, then the court on their own motion has to go and seal them. So you could automatically seal a record, or the records are supposed to be automatically sealed, even in delinquent conduct and CINS cases. And so usually if a juvenile is of a certain age, not a juvenile anymore, and he hasn't really committed any crimes, kind of just reformed. You go through that puberty phase where life could really take a left for you, but it doesn't. You kind of just hang on and get over puberty. You made all your mistakes, trying to get into college. Usually those events to me trigger my mind that I need to look at something to see if they're eligible, to see if their records are cleaned up. This is kind of the one that's important, the one that involves us because it's not automatic. We have to file an application. It's with criminal offenses or juvenile offenses that require that involve delinquent conduct. And so the petitioner has to be at least 18, and have to be at least 2 years after the event took place. So they could obviously be charged when they're 12 years old with some of these offenses. And the waiting period is at least 2 years to elapse from the day of the final discharge. Does not have any delinquent conduct pending, was not transferred from juvenile court to criminal court, an adult, certified adult prosecution, and has not as an adult been convicted of a felony. Does not have any pending charges as an adult. The application itself has to include all these things. It was a late update, Ira. This is the email that I sent you, the subsequent email I sent you. There is a sample application.
It's in there.
It should be in the packet already. And it will include all these things that the statute kind of requires. And there are instances where there's, where the person is ineligible, and you guys can look at the PowerPoint to kind of look at. Some of the deadlines are different. The expunction deadlines are 30 days. The sealing applications from the family court, juvenile courts are 60 days. So just kind of be mindful of some of those nuances and those changes. Probably the most important thing on this slide is that last link is linked to the juvenile law section of the Texas State Bar, and they have forms and resources on their website. So you can get to the actual form that's going to get the job done. So that's kind of all I have. I think we're right on time. I think we have 5 more minutes. Feel free to let me know if you have any questions, take a break, or thank you for coming.